Welcome. This is Barry Baines from Baines Law, a legal miscellany where we regularly podcast about cases and legal issues, as well as talking to professionals and others who have experience of our legal system. Today's guest is a leading criminal defense barrister with over 25 years' experience, who has represented clients in some of the most complex, serious, and headline-grabbing cases. He is a QC who is also a popular writer and commentator on topical legal issues for national publications, television, and radio. Presenter of the five-part 2020 BBC television series Crime, Are We Tough Enough? He is also the author of Justice on Trial, a book which challenges everything we think we know about crime and punishment in Britain and presents radical solutions for our broken and failing justice system. We extend a warm welcome to Daw QC. Chris, thank you very much for giving up your time to talk to us today.
No problem, good to meet you.
In your book, Justice on Trial, you deal with what you describe as dysfunctional prisons, pointless drug laws, and unnecessary punishment of children. In that context, I wonder if I may start by asking you about the huge backlog of cases in the criminal justice system. As I understand it, there are around 60,000 cases outstanding in the Crown Court and 350,000 in the magistrates' courts, with no serious proposals for doing anything about it. Do you have any views on this?
Yes, I mean, you're absolutely right. Your numbers are very close to the current sort of numbers that are in the backlog right now, and they're not getting any smaller anytime soon. My view is that, you know, the state of the criminal justice system is a sort of an example of a national emergency, just as there are national emergencies across the whole range of our public sector institutions, in particular the health service, but also other parts of our kind of national life. And the difference is that we just haven't prioritized the justice system in the way that we prioritize those other things. So we haven't flooded the justice system with resources. We haven't, for example, you know, brought back retired judges or increased the recruitment of recorders and judges at the other end of the spectrum to increase the number of courts that can sit and deal with this backlog. But we also haven't addressed the fundamental issue that really we criminalize far too many people. And that's one of the reasons why our justice system is so overburdened, is because it's full of cases that, in my view, as you know, as you've read the book, but in my view, shouldn't be there at all. So we have an opportunity, actually. We have a sort of almost generational opportunity, if we wanted to take it, to strip away a lot of the unnecessary cases that really have no place in the justice system, particularly young people, particularly those who are suffering with mental health problems, who make up such a large proportion of our criminal justice system, but also in the meantime to start bringing through a new generation of judges and bring in emergency measures, whatever it takes to get these cases through. There's no sign of any of those things happening at the moment, and that's going to mean that this problem continues for many years to come.
Yes, indeed. I mean, in the past, so often, I know when I prosecuted for a while, one of the measures was just to drop cases.
Yes, and that would be a wise move. I mean, you're right. I mean, the CPS did change their charging standards during certainly the first year of lockdown, and said that, you know, we're going to rule out cases that are really at the bottom end and really marginal cases, purely out of the sort of pragmatic realization there weren't enough people to deal with them. There weren't enough CPS lawyers at the time, even if you don't discount the number for those who were out isolating or ill with COVID itself. We already didn't have enough even before that. So the CPS took a fairly pragmatic view, but unfortunately it wasn't quite pragmatic enough, because the backlog continued to mount and continues to be a problem to this day. But I mean, you make a very good point, which is, you know, why are so many cases that result often in non-custodial sentences or short prison sentences, which actually make ultimately the crime problem worse? Why are they still being brought and just added to this mountainous backlog, which has got no end in sight?
Yes, so many cases, particularly in the magistrates' court, end up with no real disposal, don't they? An enormous number of conditional discharges, for example.
Well, there's a large number of those, and you have to question whether they really needed to be taken to court at all, or whether, in fact, they could have been dealt with either by just an informal warning or a formal caution. But this, for me, the biggest problem in our kind of revolving door justice system is that magistrates are handing out short sentences of several months, and those sentences are known to be the least effective in reducing reoffending and the most effective in increasing reoffending. So, there are these sort of systemic problems with our entire approach to sentencing, to charging decisions, to the criminalization of activity, which is really kind of marginal in terms of its criminality, and in many other countries probably wouldn't be criminalized and certainly wouldn't result in charges and prison sentences. So I think these are all contributing to this overall problem that, cases are being delayed. I have cases being delayed for years and years, some cases going off into 2023, 2024, and you kind of have this complete disconnect between the events that give rise to the prosecution in the first place and the trial. There's such a huge gap between the two that it's difficult to see in some cases how you're ever going to get a really fair trial for either side, for victims and witnesses or for defendants, because the passage of time is almost inimical to the pursuit of justice. It's a cliche that justice delayed is justice denied. There are issues and nothing's being done about it.
The government's indicated it's going to implement provisions of the Criminal Justice Act 2003 to permit magistrates to impose sentences of up to 12 months. So I take it your reaction to that proposal wouldn't be favourable either in the circumstances.
No, and the purported reason for that is that somehow it's believed that that's going to reduce the backlog in the Crown Court. And I just don't understand the logic of that at all. Because if magistrates are given greater sentencing powers, then that increases the incentive amongst those who wish to stand trial to elect Crown Court trial, if it's an either way offence, as it would be in this case. So it kind of incentivizes people to take the case to the Crown Court. But also, the more sentences of imprisonment, particularly getting towards that 12-month point that magistrates impose, the more appeals against sentence and indeed possibly conviction that there will be from the magistrates court to the Crown Court, where the sentence is heard and reviewed on appeal. So that will increase the workload of the Crown Court, because inevitably, the more long sentences in magistrates' terms that there are, the more appeals there'll be. So I just don't understand where the logic of this comes from, that supposedly it's going to save something like, on each thousands of different days of thousands of days of Crown Court time a year. I just don't see any scientific basis for that. In my view, at best, it will be neutral in terms of the impact on the Crown Court. And at worst, it will increase the Crown Court's backlog and increase the workload of the Crown Court. So I just think it's just not the answer. I gave you some of the answers earlier. You can't get away from the fact that we don't have enough courtrooms sitting to deal with these cases, and tinkering around with who's going to pass sentence and how much magistrates can pass in terms of sentence isn't going to make any difference to that. So it's just a bad idea.
Yes, exactly. And the appeals against conviction, of course, in the Crown Court take place by way of rehearing.
Exactly. So, you have a trial that may have taken a day or a day and a half, or sometimes even longer in the magistrates court, and that will have to be reheard in its entirety with all the witnesses in the Crown Court. Or, as I say, you'll have people who say, well, if I could get 12 months, even if I have a trial here, then I may as well elect to go to the Crown Court, where at least I've probably got a better chance of being found not guilty, which statistically is the case. So you just might end up with this perverse incentive for people to take cases to the Crown Court that might have stayed in the magistrates court. So it's I just think, the other thing is, of course, that not just appeals, but are we going to get more committals for sentence from the magistrates court? And I just feel like it's a badly thought out policy. There's no evidence that it will work, and it's just an announcement being made, to curry favour with the magistrates, because the Magistrates Association have said they're in favour of this. I'm not entirely clear why they are, but they are. But mainly, it's just a gimmick that is, it's an announcement for the sake of an announcement.
And not only is it shortage of staff, is it? It's also the number of court centres that have been closed. In the last 10 years, it's been an enormous number. There was a parliamentary answer given today. I think you may have probably seen it.
Hundreds of them, yeah, hundreds of magistrates' courts and a significant number of Crown courts. And not only is it court centres being closed, but it's lack of capacity within court centres. So even if you have a court centre, a large Crown court centre that might have 12 or 14 or even more sometimes courtrooms, that doesn't mean they're all in action on any given day, because, you know, set aside the staff who are isolating and the COVID impacts which have hit the court system so heavily. We just don't have enough judges. We don't have enough judges to sit, particularly on complex or serious cases, and particularly on cases which form one of the largest elements of the backlog, which are sex cases and allegations of rape and other forms of sexual offending. You know, those require specially trained judges, and there just aren't enough of them. So the backlog of those cases is particularly acute, because those are the cases where there is a real incentive or real premium to be had in terms of justice on getting them into trial quickly. You know, if a victim of rape has to wait 2 or 3 years to give evidence, that's an extraordinary, in my view, that's a miscarriage of justice, whatever the rights and wrongs of the case and whatever the ultimate verdict. There is something seriously wrong with a system that makes anybody wait 2 or 3 years to give evidence about something that happened to them, and for a jury to be able to consider, you know, the justice of the case. And inevitably, victims face an uphill battle to remember detail after such a long period of time. And sometimes those memory features are the sole reason why the defendant may be acquitted. And that cannot be right.
And of course, some just fall by the wayside, don't they?
Yes, and many do. I mean, we already know, you know, that only 1.6% of reported rapes ever make it into court at all. So a tiny number anyway. But if amongst those 1.6%, you're seeing hundreds of complainants, many of whom will actually have been victims of these crimes, saying, I've just had enough. You know, I've had clients who perhaps have been in this country coming from abroad and who have been the victims of these sorts of serious attacks. And they've said to me, look, you know, I may as well go back to my own country because it's just never going to get resolved. And I can't just hang around forever with my life on hold waiting for the English legal system to catch up. And you know, there are many cases out there where victims are just saying, it's too much. The waiting is too much. The lack of information is too much. The fact that potentially a defendant who was in custody and would have been in custody if the trial could take place within 3 or 4 or 5 months, but they're released on bail because of the delays. So that means that victims are in fear because their attacker is on bail purely because there is so much delay in the court system. And all of these things are just working to the disadvantage of victims and ultimately undermining public confidence in the justice system, which I think is at an all-time low anyway.
That brings us naturally, I think, to the age of criminal responsibility, which is one thing I feel quite strongly about. You have a chapter in your book called Why Children Should Never Be Criminals or Are Never Criminals. In this country, children may be criminalized at the age of as young as 10. Some of us may think that's ridiculously young, when most European countries set the minimum age as 14. You think there's a better way?
Yes, most do. Most do, and some, as I point out in the book, set the minimum age at 18, which is the same as the age of majority and the age at which young people assume all of the rights and responsibilities of adulthood, and certainly in terms of rights, that's the case in Britain. You know, you can't vote until you're 18, and there's a whole range of other kind of civic rights that you don't fully engage with until you're an adult. And I think it's really as straightforward as this. You know, if you don't trust someone because of their age to have the maturity and responsibility to make the law, in other words, to be a voter, and to be able to elect politicians who can decide what the law should be, then I don't really see how you can, on the other hand, argue that they're old enough to be subject to those laws in exactly the same way as an adult. Of course, the public needs to be protected from the very tiny number of dangerous children, and they are tiny in comparison to the number who are put through the criminal justice system every year. The number of genuinely physically dangerous young people is minuscule. but the public needs protection from them. But what the public actually needs it most of all is to ensure that those young people who do find themselves in trouble with the police or being arrested or coming to the attention of law enforcement are pulled away from whatever it is that's causing that, are given access to education and support to see them through whatever trouble in their life is putting them in that position, and can come out of childhood and into adulthood without the rest of their life being blighted by actions that they took when they just didn't have sufficient maturity to be judged as being criminal. I mean, anyone who has either 10-year-old children or 10-year-old grandchildren or even knows 10-year-old children, they are just not mature enough to understand and process their actions and the consequences of their actions in the way that most adults are. I mean, some adults aren't, but the 10-year-olds just are not equipped for that. And so to put them into a criminal court and treat them as if they're an adult criminal, I think it's just abhorrent, and it's morally wrong. In my view, it breaches the United Nations, Charter on the Rights of the Child, which we kind of ignore in this country largely in so many different ways anyway. But just as a matter of basic common sense, if you blight a child's life with the label of criminal at the age of 10 or 11 or 12 or whatever the age may be, you may as well tattoo criminal on their forehead, because their life chances will be effectively much the same as if you did that. No one would ever give someone a job if they had criminal tattooed on their forehead, and they live their lives with the same criminal record and the same impacts as if that were the case, and it just doesn't make any sense. And I think it's just a cruel system designed to, generally to punish those from certain parts of our society and community much more than those from others. We know that disproportionately it's the children of the lowest socioeconomic groups and in very small pockets of our urban environments on the whole who are subject to the criminal law. Most other 10-year-olds or children of an older age, particularly those from middle-class families and elsewhere, never go anywhere near the criminal justice system, even though they may make the same mistakes and do the same things, in particular in relation to drugs. And I'm sure we'll come on to talk about that. But children experimenting with being in possession of drugs is common across the entire social spectrum and all over our society. But only younger, predominantly black children in the inner cities tend to get arrested for it and tend to end up with a criminal record for it. And their life chances are massively hampered when they're already disadvantaged in so many ways in our education system and socially and otherwise. So it's just fundamentally, to me, it's wrong to treat children as criminals, and no child should be labelled in that way. We should protect the public from dangerous children, but even dangerous children should be given an education and opportunity to move into adult life and put their past behind them.
You mentioned drugs, so let's come on to it. What are your views about criminalising drugs?
Well, it's probably the single largest policy error that has been made in our society in the past century, because the consequences of drug prohibition in terms of harm to those who use drugs, from the fact that they buy their drugs at such high costs from dealers with absolutely no idea what they're really taking, and so overdose levels and all the other harms that go with it. Drug-related crime, the impact on society from the need for people who are using drugs, particularly highly addictive drugs like heroin and crack, to get more and more drugs and have to find hundreds or even thousands of pounds a week. The amount of the crime wave that's created by that sort of huge increase in price that's caused by prohibition. And of course, just the sheer utter waste of money of all of the policing and law enforcement, and the fact that half or more of our prison population are in some way in there because of drug prohibition, either directly in terms of drug offences or drug-related crime or crime committed because they're on drugs. All of these kind of basic kind of common sense points that drug prohibition causes more crime, causes more harm, causes more death, increases the cost of policing and our society. And of course, we were talking earlier on about the huge backlog in the system. When we stripped away drug crime, the system would have plenty of capacity. I mean, it takes up a very large proportion of the business of many Crown Court centres and indeed many magistrates' courts. And it's totally unnecessary, because there's a clear path we could take towards licensing and regulating drug supply, which would protect the health of users, which would dramatically reduce drug-related crime, and which would free up resource in our criminal justice system to deal with things that we really need to deal with, like the very large number of unresolved sexual offences, as I talked about earlier. It's utterly abhorrent that we've got large drug conspiracy trials taking place in court centres where rape victims are being told, we've got no space for your trial. That just doesn't make any sense when we could get rid of all of that and make the world and the country a safer place in the process.
Okay, I wonder if we can change tack a bit now and talk about unduly lenient sentences, which the current law officers seem to be quite keen on. So we know they can refer cases to the Court of Appeal when they think they're unduly lenient. In one recent case, the Court of Appeal felt it necessary to remark that it was, to say the least, an unusual submission by the Attorney General, but the judge fell into error by failing to depart from the guidelines. I wonder how this chimes with your general views about prison sentences and the attitude to them by the government.
Well, we've seen our present Attorney General, who is sort of gets in front of the cameras and journalists as soon as there's any high-profile sentence in any case, and complains that it's too lenient and says that she's thinking about appealing it. And that sort of politicization of the role of the Attorney General as a law officer, as you say, which is a sort of, although they're a minister of the Crown, they're supposed to exercise independent judgment. And I'm afraid we've seen the Attorney General basically becoming nothing more than a mouthpiece for sort of, Boris Johnson and Priti Patel, and not exercising that degree of independence, which we've seen in the past. But you're right to point out that judgment, where the Court of Appeal has said that this is I think they described it as baffling or confusing or something like that. But when the Attorney General is coming to the Court of Appeal and saying, we accept that the judge fully complied with the sentencing guidelines and that they took account of all of the relevant aggravating and mitigating features and passed a sentence that was within the guidelines, which the judge is required to read and pay attention to. But we're saying it's still unduly lenient, and the judge was duty bound to go above the maximum level within the guidelines. And the Court of Appeal, I think, we're just sitting there reading the judgment, as I have. I wasn't in court, but I've read the judgment. I think I was just sitting there thinking, what on earth is this about? It doesn't make any sense. You can't possibly argue that a judge who takes account of everything relevant and passes a sentence within the guidelines is somehow acted perversely and so kind of out of the sort of reality of the case that the Court of Appeal should intervene and increase it even beyond the top of the guide. I mean, I don't think that's ever happened before. I don't think we've ever had a case where the Attorney General has argued that a sentence within guidelines should have been increased above guideline, and the Court of Appeal agreed. So it just shows a complete lack of judgment on the part of the Attorney General, and frankly, a complete lack of independence. And that politicisation is quite worrying, because the Court of Appeal have also got plenty of work to do, and they don't need to be used as a political football by the Attorney General and the government to try and prove a point about how tough they are on crime in inverted commas. Just
bringing populist politics into the courts, isn't it?
Yeah, and I mean, it's very sad. We've seen successive Lord Chancellors and now successive attorneys general to doing the same, that, as you say, that sort of, populist rabble rousing around, criticising judges for a start, openly and publicly, and often in quite scathing, almost personalised terms, rather than accepting that, being a judge is difficult and that the responsibilities are high, and that also that judges are required. They can't pass whatever sentence they like just as an emotional reaction to how nasty the case is. They have to look at the sentencing guidelines. I don't agree with many of them, but they are what they are, and they are in place. So judges, really shouldn't be criticised for observing and following guidelines which are imposed upon them from elsewhere. If there's to be criticism of guidelines, then and the government wants to increase sentencing levels, which I'm afraid it has done in a number of ways over the last couple of years, then that has to be done openly and publicly by legislation, and Parliament, deciding that sentences need to be higher or whatever the case may be. But to criticise judges for doing their job properly, I think is particularly unpleasant when it comes from a government who's got a history of complete disregard for the law and has itself, of course, been found to have broken the law on countless occasions, and possibly we might see another load of examples of that over the next few weeks with at number 10, and its many parties when the rest of the country were in severe lockdown.
We can't wait for the outcome of that.
No, I mean, I wasn't actually a big fan of the police becoming involved in it, because I felt that it was a waste of time and public money and indeed police resource, which is pretty scant. And I would have much preferred to see the Gray report just published with all of the photos and videos of whatever went on at these parties, and let the public and Parliament decide what to make of it, rather than the police dragging their heels for months and possibly letting the government off the hook.
Now, discounts for pleading guilty. We know that in order to get the maximum discount for pleading guilty, you plead guilty at the earliest possible stage. And if found guilty at trial, then there's no discount at that stage. Sometimes the discount's sufficient to avoid prison altogether. In your experience, does that sort of pressure on a defendant lead to some people pleading guilty to offences they haven't committed because the risk of a heavy sentence is too great?
Well, I've certainly had clients say that to me. I've had clients say, I didn't do it, but if I don't go to prison and I can do a deal in inverted commas, I'll do the deal because I don't want to take the risk that it goes wrong at trial and I end up going down for, either going down at all or going down for a lot longer. So I've had clients say that and give me, and I have to obviously get them to put that in writing. If they're saying I'm not guilty, but I'm pleading guilty anyway, then, I need to make sure that that's recorded, because I don't want them coming back later and saying, well, I told my barrister I didn't do it. And that's their choice to do that. But I think there is a significant issue now with the pressure on guilty pleas at the very beginning of the case. So it used to be the case that you would get the full discount, as it's called, the 1/3 discount for a guilty plea, if you pleaded guilty sort of after you'd had all of the evidence and after it had all been served and after you'd had the proper opportunity to take some legal advice about what your plea should be, and potentially around offering a plea to a lesser offence or something like that. But now, as I think we're pointing out, that you have to plead guilty at the very first hearing in the magistrates court to get that full third discount. And that often means it could be the day after you've been charged, because, someone could be arrested one day, charged, kept in the police station, taken the magistrates court the next day, and they've barely spoken to a lawyer. And often those who go to police stations are not lawyers in the full sense of the word. They're unqualified people who, maybe have been on a 2-day training course or something. So, to expect people to make these really big decisions, particularly on very serious cases where they may be looking at many years in prison, the very, very first hearing, I think, is a worrying kind of development. And I think it was much better when the full credit was available up until that first substantive plea hearing, after service of the evidence, and when, there should, in theory at least, have been the opportunity to take proper advice. Because the problem with the current system is that many do plead not guilty or give no indication of plea at the very beginning. And by the time they get to that hearing where all the evidence has been looked at and so on, the credit may have reduced to 25 or even 20%. So the incentive to plead guilty is much less at that point, because the difference between the outcome if they do and the outcome if they lose the trial is a much smaller margin. So I think overall, I think it's counterproductive. But I mean, one of the things that I think would worry me is if we went down the American route, where the difference between pleading guilty and not guilty can often be not a third as our kind of maximum discount in theory, but it can be 90%. I mean, someone could be looking at 40 years, or they can plead guilty and get 4. So, you can imagine the pressure in that system for someone who's innocent to say, well, if I'm looking at 40 years or life without parole and they're offering me 5 and I could be out early, et cetera, I suspect it's a much greater problem. I don't think there is a huge problem in our system as yet with completely innocent people pleading guilty just to get that discount on sentence. That's not, over my almost 30 years of criminal law. I don't think that's the issue. The issue, in my view, is that people may plead guilty when they had a viable legal defense and just they got no proper advice about it, or they plead guilty to maybe to a more serious offence than the one that they really should have pleaded guilty to, because there hasn't been time for the law for a qualified lawyer to look at the case properly and to give them some proper legal advice. And it has to be said, in this day and age, that they're, legal aid lawyers who deal with the great majority of these cases, criminal cases, are so overburdened and so underpaid that they often don't physically have the time to give that level of attention, to give that sort of advice. And they certainly don't in the very early stages. So, all of these problems kind of come together to create a perfect storm of, bad decision making and, a bit like with the magistrates' new sentencing powers and so on, perverse incentives. You end up with people, as I say, who've got nothing to lose. I may as well run a trial. If they're only going to give me 10% discount, then I'll take my chances. And then you end up with trials that cause more backlog and all the rest of it. So I think there should be a clear principle around guilty pleas, is that, of course, someone can choose to plead guilty if they wish at the beginning without waiting for the evidence, and they should be able to do that. But I think that the presumption should be that you'll get full discount up until the point that you've had legal advice from a lawyer and proper legal advice based on the evidence. Until that point, I think it's wrong to reduce the amount of credit that people get when they plead guilty later on in the process.
And that brings me naturally to our last topic, really, which is that there's probably never been a greater need for skilled criminal advocates to represent accused people in the courts. And given the downward pressure on legal aid rates and young barristers leaving the profession because they can't make ends meet, how do you see the future of the criminal bar?
I think the criminal bar will shrink over time. It has shrunk already in real terms, as it were. You're looking at the number coming in versus the number going out, the number of pupilages, which is much smaller in criminal law than it was when I started out almost 30 years ago. I think it will shrink, and that's partly as a result of those features in terms of funding, and it's partly as a result of reduced workloads, and it sounds counterintuitive when there's this huge backlog, but because of the smaller number of cases actually getting to trial and going through the system, there's a sort of a reduction in overall work available. There's also the issue of many cases in the Crown Court in particular are dealt with now by solicitors or by in-house barristers at the CPS in particular. So the independent criminal bar has seen leakage of its work in different directions. But I think economic forces are as valid and important in the criminal law as they are in anything else, and it's as simple as this. To the extent that money doesn't flow to particular kinds of work, there will be a reduction in those willing to service that work and service the work at the rates. I mean, the criminal bar have announced a ballot this week about effectively industrial action, because the government won't commit to any particular timetable in terms of addressing some of these huge shortfalls in funding. And so we're going to see potentially criminal barristers going effectively on strike, I suspect, over the next few months. Something like 94% already supported some form of action. So all of this, young people I speak to regularly, and aspiring lawyers and particularly aspiring barristers, and many of them say, we are just put off criminal law because everyone says it's, there's no money in it and it's so poorly paid. Now, where that ends up is, I think there will be we already have a two-tier system, if not a 2 or 3-tier system, but we'll end up with a system which is very similar to the American system, which is that, most people, 90% of the population who can't afford to pay for a lawyer have, the public defender in America, and over here they will have people on legal aid. And those public defenders or legal aid lawyers have so many cases, because that's the only way to make ends meet, is to take on lots and lots of cases, that they'll you'll be lucky to get to see your lawyer at all. I mean, that's happened in the past recently, where people have been on trial for murder and they've not met their barrister until the trial. And back when I started, that was unheard of. You would have had 3 or 4 or 5 conferences at least with someone charged with murder, and now, as I say, people are lucky if they see them once. And that's quite extraordinary when you think about it. But that's the direction of travel. The direction of travel, I think, is that at one end of the market, Defendants will have access to their lawyer for a very small amount of time. The case will be very poorly funded. Getting access to expert witnesses and the rest is going to be very difficult because those rates have been cut to the bone. But at the other end of the spectrum, you're going to have, wealthy defenders will have access to the absolute best. And there will be, and there is an elite group of barristers and solicitors for that matter, who only act for those who can afford to pay, substantial fees. And I sometimes act and often act in those cases. And the difference between the resources that we have as a well-funded, privately funded legal team defending someone versus, for example, a co-defendant in the same case who's has legal aid funding, there's absolutely no comparison. I mean, it's a bit like a Premier League team playing, fourth division local side from Essex or somewhere. I mean, there's just no comparison. There's no comparison in resource. There's no comparison in the sort of numbers that you can have on the team. And there's no comparison in the access you have to expert witnesses. Some of my cases for well-known people and, even people in the public eye, we might instruct 3 or 4 experts, on a given issue because we can afford it, because the client can afford it, and they want to see what's the best evidence that they can possibly get. Whereas on legal aid, the same case, the defendant's lawyers are struggling to get an expert at all, any expert, to even look at the case. And when expert evidence is so important, you can imagine that the disadvantages that are caused to those who can't afford it and the huge advantages to those who can. So I think the end result is a smaller criminal bar, probably a large number of people working for very low rates and doing a high volume of work, and a relatively small number working at very high rates and doing a small amount of work, but being able to do that work in a very different way. And that's the direction of travel. That's what we see across the Atlantic, and sadly, that's the way it seems to be going here.
Chris, thank you for sharing your views, which I know will be fascinating to all our listeners, and especially those with interest in criminal law or who have a criminological interest. Thank you very much.
You're welcome, Barry. And if any of your listeners want to kind of see any more of my content, I know hopefully that some of them will read Justice on Trial, but they can follow me on Twitter at CrimLawUK. And I also have a YouTube channel, which is particularly of interest to students and people who are aspiring lawyers. I have lots of content on there for them. And of course, people are welcome to follow me on LinkedIn, where again, there's content of all kinds that I post on there mostly about criminal justice, but sometimes about other things. So I hope anyone who's interested will connect up with me via one of those channels.
Thank you for listening to Baines Law. Listen out for future podcasts where we will continue to discuss issues of interest to the legal community. If there is a professional perspective that you would like to share, get in touch via our website at www.barrybaines.com. You can also follow us on Twitter at Baines Law. We look forward to presenting to you again very soon on Baines Law.